Good morning. Welcome to our webinar today. Does your website comply with the ADA and what every business must know? My name is Jairo Batista. I'm a consultant with the Florida SBDC at UCF. For those who are new with the SBDC at UCF, we are a small business development center, and our goal here is to help businesses grow and succeed. And the way we do that really in 4 ways. First, we provide no-cost consulting. You can come and speak with us as often as you like, as much as you like, with one of our experienced consultants, and it'll all be no cost. Our consultants are experienced in a wide variety of business areas, including human resources, operations, sales, financing, and loan preparations for those who are looking for small business loans. Additionally, we provide no-cost market research. We understand as small business owners, you're tasked to make a lot of tough decisions for the future and the health of your business. And a lot of times you're depending on Google and other different resources that may be a little bit too much. Come speak with us. We have, thanks to our connection with the SBDC statewide network and also the University of Central Florida, we have access to a wide variety of databases, and I'm sure one of those tools can help you make the best decision for your business. Additionally, we offer different program and services for second stage companies. So if you've been in business for over 2 years and are just looking to get to the next level or get over the hump, we have a wide variety of different services, including international trade services for those who are looking to export their products overseas. Through our sister program called the PTAC, we can offer government contracting services for those individuals who are looking to gain federal, state, and local government contracts. And you can find more information about our other programs on our website, www.sbdcorlando.com. And lastly, we help support small businesses through events and programs like these. Today, obviously, we're talking about ADA compliance and your website. Tomorrow, we'll be presenting a webinar on government contracting proposals. And then on Thursday, we'll have an HR attracting talent webinar as well. And for more information, please visit our website again or subscribe to our newsletter. Before I introduce our speakers today, just a couple of quick housekeeping notes. First, everyone is muted. However, please feel free to drop any questions in the questions portion of the GoToWebinar platform. And lastly, by the end of the day, you'll receive a webinar evaluation. Please fill that out because we use that data to get a better understanding of how well we did today and also what programs we should offer in the future. So without further ado, I'd like to introduce our speakers today. From Sheffield, Lohman, and Wilson, Keith Hesse and Dillon McColgan. Keith is a Martindale-Hubbell AB-rated attorney with a strong background in commercial and corporate matters, non-compete agreements, real property litigation, probate, trust and proceedings, and class actions. In addition, he has extensive experience in litigating ADA disputes, both in the context of claim physical barriers as well as with respect to websites. He's a trusted advisor to a variety of individuals, businesses, and nonprofit organizations, and has handled cases of statewide and national significance. Keith also represents a number of manufacturing clients, serving on the board of directors of the Manufacturers Association of Central Florida and working with Florida Makes. Dillon McColgan works in the Sheffield, Lohman, Wilson's Orlando office primarily in the areas of commercial, fiduciary, and employment litigation. He previously worked as an attorney for several years at one of the Southwest Florida's largest law firms. At the end of the day, Dillon finds his greatest satisfaction in working hand in hand with clients to successfully resolve their litigation needs. He prefers to address matters as quickly as possible and in a way that will improve the best possible results for his clients, often involving resolution prior to trial. So without further ado, I'd like to turn it over to Keith and Dillon.
Perfect. Well, thank you, Jairo, for that introduction, and thank you for assisting and coordinating this presentation. Good morning, everyone. I'd like to thank you for attending this presentation on an issue that we think is critical to businesses of all sizes across the country. Now, as the title suggests, we're going to be discussing website compliance with the ADA and what we believe every business must know moving forward to ensure that they are hopefully in compliance with Title III of the ADA. To begin with, what I'd like to go through is just a general overview of what the ADA consists of. As I'm sure most of you may be aware, that the ADA stands for the Americans with Disabilities Act. And it contains and consists of 5 separate titles. Title I is concerning employment and employers. Title II sets out guidelines for public services. Title III, which is going to be the main focus and primary focus of this presentation, is covered in Title III. Title IV concerns telecommunications, and Title V is what's considered the miscellaneous title, or the ADA's catch-all provision. Now, as I stated, Title I concerns employment and employers. It federally applies to businesses of 15 or more employees. And essentially, in essence, it requires that an employer take reasonable modifications or make reasonable accommodations to its employees that may have a disability, unless it imposes an undue hardship on the employer to make those accommodations. Now, what is considered an employment accommodation? Now, typically, this could be considered as an employer providing quieter workspaces for certain individuals or certain employees. It would require that training and other written materials be provided in an accessible format for those employees that may have a disability. For those employees that have hearing limitations, it could require teletypes for use with telephones. And generally speaking, it requires an employer to provide time off for someone who needs treatment in connection with their disability. Now, Title I of the ADA is enforced by the United States Equal Employment Opportunity Commission. And as most of you may be aware, this is called the EEOC. Now, with regards to website accessibility and ADA compliance, the EEOC has and will take action against an employer or a business whose website is not accessible to an employee. So not only does these website concerns apply to public accommodations, it also comes within the realm of employment issues under the ADA. Now, Title II is with regards to public services, and these would be the concerns that are faced by public service accommodations. The best examples of these types of accommodations would be public pool accessibility, where you might find a crane or a wheelchair lift to provide access to a pool. If there is a public event or public forum, event tickets must provide for accessible seating for those who may be disabled, as well as lower drinking fountains and ramp access at municipal or government buildings to provide those who may be limited to a wheelchair. Now, unlike Title I, Title II is enforced by the Department of Justice as opposed to the EEOC. And the DOJ, with regards to website accessibility under the ADA, has taken the position that a website being promoted or by a city or municipality must be accessible as a program of the city. This could be in the form of a city which provides the option to pay certain fees, fines, or other bills for services on their website. These types of websites must as well be accessible. Now, for the main focus of this presentation, we're going to be talking about public accommodations under Title III. What are public accommodations? The typical public accommodation would be for a company or business to have accessible restroom stalls, handicap accessible parking spaces, permitting service animals on their premises during business hours, and as the main focus of this presentation, accessible websites for the company or businesses, patrons, and consumers. Now, unlike Title I and Title II, there is no regulating agency under Title III. Instead, each court in which an ADA Title III claim is made determines what constitutes proper accessibility and compliance with the ADA. And as you can imagine, with each of these cases across the country, that means that there's quite a wide variety in what a court in one part of the country compared to another part of the country determines what is adequate accessibility. Now, with regards to the final two titles, telecommunications and miscellaneous items, Title IV and Title V would require telecommunication relay services, teletypes, like I previously mentioned, as well as telecommunications devices for the deaf or hard of hearing. For the purposes of this presentation, we're not going to get into the weeds for miscellaneous accommodations. However, the ADA requires that the U.S. Access Board issues its accessibility standards and requires that federal agencies provide technical assistance to implement these standards.
Okay, thank you, Dillon, for that introduction. As Dillon mentioned, we are going to focus on Title III, public accommodations. And this slide says, back to the good old days, drive-by lawsuits. The ADA was enacted in 1990, and it took a few years for all the regulations and administrative underpinnings to get established. And so by 93 to 95, you have the ADA out there, you have Title III public accommodations. And what we saw developing was a number of lawsuits. We would call them drive-by, because what would happen is plaintiffs would get in a vehicle and visit a number of typically retail establishments, restaurants, hotels, etc., mini marts, go in and well, they'd start in the parking lot and look for the handicap spaces and the handicap signage, and then they'd go in and they would notate all the deficiencies under the ADA in terms of public accommodations for the disabled. The cases became very, very numerous, very persuasive. It really did become a cottage industry. There were a number of cases here in Central Florida, in Orlando, the Middle District of Florida. These were brought in federal court. In fact, there became so many cases that the federal court developed a certain procedure just for those types of cases to have them move along very, very quickly. But they all involve facilities and the usual things you think about facilities with the ADA, from handicap signs to restrooms, to the spacing. The ramps were very important, the slope of the ramps. And additionally, what you had is, as Dillon noted, this the DOJ, Department of Justice, did promulgate a very thick compendium of specifications for accessibility for physical locations. They were called ADAG, the ADA Architectural Guidelines. So you knew what had to be on your note, on your handicap parking sign. You knew how wide the doorway had to be. You knew what the slope of the ramp had to be. So you did have those specific procedures and those specific guidelines to look to be compliant. Nevertheless, as you can imagine, many businesses were not compliant, and it was a field day many times for the plaintiffs' lawyers. Next slide. So as we go through the 90s, of course, the internet gets more and more pronounced. The usage becomes more and more widespread, and of course, websites start proliferating, and they become almost, if not universal, for businesses. As we get further into the 2000s, after 2010, what we start to see is a new front in the litigation of ADA claims concerning website accessibility, usually for the deaf or hearing impaired, or the blind or visually impaired individuals. And as with most things with the internet and websites, they make things easier as opposed to going to physical locations. Well, it also made, unfortunately for defendants and businesses that were in the crosshairs, it made it easier for plaintiffs to bring these actions, as opposed to getting in a car with someone and visiting a number of locations physically. You could just stay in your home or apartment, click, open up your laptop or your desktop or your phone, and visit websites and see if those websites were accessible to you as visually impaired or hearing impaired. And so what we began to see was a number of these lawsuits then, I'd say in the 2013 to 2015 time period, really start to proliferate and gain a lot of momentum. And they were different in some respects from the drive-by ones with the physical facilities, and we'll pick up some of those points a little later on. So let's go to some of the statistics about what we're looking at. Dillon, next slide. So we do have various entities that do track these suits, and so what do the statistics say? The first one is really will make you stop and think that 97.4% of 1 million home pages had detectable accessibility failures as of a few months ago. That is an incredible statistic, and for a lawyer, certainly looking at a case, if you were told, well, you have a 97% plus chance that the case you will bring will result in some liability or showing of liability, whether it is minimal or not, that is an incredible percentage. So the huge majority, almost all websites have detectable accessibility failures, and most of those are not isolated failures. Many times it's 50 or more pages on the website. Next slide. So, as I mentioned, these lawsuits have really picked up steam since 2013 to 2015, and this shows the ADA digital cases, which are the website cases, and their increase just in the last few years. And what's interesting to note is that even though it's not shown here, while there still are the drive-by lawsuits, the physical facility lawsuits, they somewhat plateaued in this period we're looking at, and certainly plateaued or even dipped a little bit during the pandemic over the last year plus. But the digital lawsuits certainly have not, and we certainly expect that trend to continue. Next. So where are these lawsuits being filed? Well, unfortunately for us, Florida is in the top three, and in fact, the big three, New York, California, and Florida, account for 90% of all ADA digital lawsuits being filed. So we do see quite a number of them here in Florida. New York leads the pack, followed by California. And as we'll talk about a little later on, these are where the lawsuits are filed. This does not necessarily mean where the defendant is located or headquartered or has its business. So just because you're in Central Florida doesn't mean you may not be sued over your website in California or New York, most likely, or some other locale. And we have actually seen and handled cases where that is the case. Next slide. So what do the statistics say? Unfortunately, it's not a very good roadmap for the businesses and the website and their websites. Unfortunately, defendants can be and have been sued multiple times, and we'll look at some of that perhaps in some of the cases. You're not safe from lawsuits even during remediation. There's at least one or more cases that we'll look at where the defendant said, hey, we're remediating and we're going to get it right, and the lower court judge agreed, but the appellate court reversed and said that's not good enough. And as I mentioned, you can be sued from anywhere, because the internet and your website is across the country or across the world. It may depend entirely on where the plaintiff is. So we see a number of these cases. You'll see when we talk about some of the cases, they're against mainly retailers, but no industry is immune from suit. So we see suits against GNC and Dunkin' Donuts, the Dallas Cowboys gift shop, the Miami Heat, suit against MIT, other governmental entities, et cetera, et cetera. One thing also to note when we were going through the overview, Title I, which deals with employment, applies to entities that have 15 or more employees. There is no minimum amount for public accommodations in Title III. So you can't say, hey, I'm a startup, I only have 2 employees, or et cetera, et cetera. Same as if you have a brick and mortar spot that's doing business and you only have 5 employees. There's no safety in being a small business, and these lawsuits target all across the board. They can be the very small to the very large and everything in between. So with that, I will turn it back to Dillon to discuss some of the current recent cases on ADA website compliance.
Well, thank you, Keith, for sharing those statistics. It certainly shows the prevalent nature of this issue. And with those statistics in mind, and Keith's mentioned that this is a nationwide issue, I wanted to just touch on some noteworthy cases that highlight some of the issues that we've discussed. First, I want to go over some cases that either have either binding or persuasive authority in cases that would be brought in Florida, as well as touch on some cases in other parts of the country to show the differences between the court and the mixed bag of results in these issues. First, with the Ariza case out of the Southern District of Florida in February of this year, they've importantly held that a website is subject to the ADA if a plaintiff can establish a nexus or connection between the website and the physical premise or the brick and mortar store of a public accommodation. Now, this is a very large distinction with regards to ADA liability to businesses and companies, and it's a jurisdictional issue because, as you will see in some of the other cases, they don't hold this position. But as far as Florida is concerned, that connection is still is a prevalent issue considered by the courts. And by the same token, in the Price case, it's a Middle District of Florida case. A few years back, the court recognized that a majority of courts agree that websites are not covered by the ADA unless some function of the website hinders the full use and enjoyment of a physical space. Again, that just evidenced this reliance that there must be some type of connection between the website itself and the brick and mortar of the business. As Keith previously mentioned, one of the notable issues that businesses face in these lawsuits is that you're not immune from suit even if you are taking the steps to remediate the issue. And that's held in the 11th Circuit Court case, Haynes versus Hooters, where the court essentially said that just because a business has assured Plaintiff A over here that they are in the process and are remediating their website, that alone does not prevent Plaintiff B from coming in and filing a claim during the time it takes to remediate the website. So it can result in this constant barrage of these website accessibility suits, even when you're doing what you can to make your website accessible. Now to look at some other cases across the country. Most notably, I want to point out the Access Now case out of New Hampshire, where the court plainly held that it appears to those courts that websites standing alone are public accommodations, meaning that some courts, depending on the jurisdiction, don't require this nexus or connection between the website or the brick and mortar store. And this is kind of a broadening of the ADA accessibility. And as far as trends are concerned, a lot of courts seem to be latching on to these types of holdings that the website stands alone, especially in line with the growing shift to e-commerce and the fact that there are entire companies that don't have a brick and mortar store and are entirely web-based. And as a lot of small companies are starting up, a lot of startups may not have a brick and mortar store. So even though, depending on the jurisdiction, just because you don't have that physical location does not mean you're immune from suit, as some jurisdictions hold. This kind of mentality is echoed by the holding in Reed out of the Eastern District of New York, where the court kind of adopted a public policy argument and adopted and recognized that the ADA is meant to be broad and expansive in its terms of non-discrimination, so that it's supposed to reach goods and services provided by websites over the internet. So there's no kind of loophole or a way for a business to avoid liability if they are solely operating through a website or online. And again, there's another case, Reed versus CVS out of California, that has had a very controversial opinion and holding, where it states that Specifically, it states whether or not a defendant's digital offerings must comply with the web content accessibility guidelines, which we'll discuss a little bit further later in this presentation, or any other non-compulsory guidelines, is a question of remedy, not liability. So this court has essentially stated that, regardless of the guidelines that are out there for a business or company to follow in efforts to make their website ADA compliant, that company's compliance with these guidelines is not the threshold for whether or not that company can be liable or not. It's simply a matter of a remedy or remediating the website to be ADA compliant. Now, this kind of presents to companies across the board a moving target, because the case states that guidelines that are out there may not protect you from liability. So that has been seen as a pretty meaningful case for the jurisdictions that adopt it. Likewise, we have the Robles case out of the Ninth Circuit. It's a 2019 case, and it effectively states that the ADA requirements not only apply to just websites, they apply to websites and apps and applications, even though the customer predominantly uses those websites and apps to access them away from the physical restaurant. Specifically, the court stated that the ADA applies to services of a place of accommodation and not services in a place of accommodation. Again, this is just another jurisdiction that adopts this idea that the website itself is standalone from the physical building of a company, and that the website alone can open up a business to ADA liability. Lastly, I wanted to point out a case from the Western District of Pennsylvania, and it's a 2021 case, so it's fairly recent. And we believe it's actually very favorable for businesses in terms of the venue and jurisdiction questions that Keith previously touched on. And it stated that the mere operation of a commercially interactive website should not subject the operator to jurisdiction anywhere in the world. Instead, there must be evidence that the defendant purposely availed itself of conducting activity in the forum state by directly targeting its website to the state, knowingly interacting with residents of that state through its website. We find this a very meaningful opinion because it kind of pulls back a little bit from where a business can be pulled into court for these ADA website accessibility violations. It essentially says that just because a business has a website that anybody can access and possibly buy something from or do search for information through the website, doesn't mean that the company has essentially availed itself to the jurisdiction or venue of wherever that person is living or accessing the website. This is a critical opinion, and we're waiting to see how many jurisdictions adopt this mentality. But like we've stated, not every jurisdiction is going to rule the same way. So at this point, it seems to be that a company can, in fact, possibly be brought to court in any jurisdiction unless more cases and more holdings rule similarly to the Murphy case. And with that, we're going to move on more specific to the jurisdiction and venue issues, and Keith is going to explain more of these issues in depth.
Great, thank you, Dillon. So as Dillon was mentioning with jurisdiction and venue, what legally that means, the jurisdiction is what court can handle or hear the matter in question. Now, the ADA is a federal law, and so that will give any federal court anywhere in the United States jurisdiction, that is the ability to hear and determine that case. Venue is what locale the case will actually be filed in. Even if a court has jurisdiction, that is, can hear the type of issue that's involved, and all federal courts can hear ADA, there's still an issue with venue. In the good old days, in the drive-by lawsuits, if your business was here, your restaurant or your hotel was here, you'd be sued here. You'd have to be sued here. Those were the good old days, because now, even though, as the graphic illustrates, you are here in Central Florida, you can be sued anywhere those explosions are occurring and anywhere else. California, New York, Washington State, Texas. So that's a big change. And Dillon was going over some of the cases in terms of how the courts are handling this. And I will only say, just to give you sort of a very baseline understanding, the district courts, when we mention the federal district courts, there are trial courts. And then the circuit courts are appeals courts over those district courts. And the United States is divided up into numerous circuit divisions. The circuit that controls Florida is the 11th Circuit. But those circuits can come to differing results, as you've seen and as we'll further talk about, in terms of how they handle these cases. So California's in the 9th Circuit, which has a very differing view of these issues than the 11th Circuit here in Florida. Long way of saying it's very, very important, may even be case determinative, where you are sued, whether it's in Florida, whether it's in California, whether it's in New Hampshire, whether it's in Pennsylvania. As we've seen, the law is different. A district court here in Florida is bound by the 11th Circuit, but it's not bound by the 9th Circuit, or it's not bound by a district court in another part of the country, and vice versa. So a California court can say, I don't have to listen to what the 11th Circuit or a Florida district court has to say about this. So always in litigation, it's very important where you're sued, who the judge is, what the locale is. It's especially important in terms of jurisdiction and venue in these types of cases. Additionally, some state laws do allow for the recovery of damages. We'll talk about in a little bit the usual relief that's granted and available in these cases is injunctive relief. That is, an order that the business do something with its website or not do something, and the award of attorney's fees and costs, but not typically damages. However, some states, and I include in that New York and California, have state statutes that address discrimination and have been applied to websites and do allow for the recovery of damage amounts. So that makes it ever more important as to which locale you are being sued in and the case remains in. Florida is a very, I think, open question. I have not seen any cases that allow damages in a lawsuit in Florida, although we do have a state anti-discrimination law, Chapter 760. It's administered by the Florida Commission on Human Relations. There are administrative procedures you have to go through. The law, by its terms, allows for compensatory damages, but I've yet to see any in cases here. So these types of cases, jurisdiction and venue, very, very important. Next slide. So a very recent case that has come out really highlights this and highlights a lot of other things. It's Juan Gill versus Winn-Dixie. Juan Gill was a customer of Winn-Dixie. He is blind, and he would attempt to utilize the Winn-Dixie website. What he found was with his technology and his devices, his speech reader technology, which basically makes audible what's on the website, was not compatible. I think he used two separate ones with the Winn-Dixie website. And so he brought a suit against Winn-Dixie saying, you know, your website is inaccessible to me. This was brought in the Southern District of Florida in the Miami area. Just note, this lawsuit was brought in 2016. He filed it in July of 2016. The 11th Circuit Court of Appeals, which is the appeals court, which does cover Florida, Georgia, and Alabama, rendered its opinion and ruling on an appeal just in April of this year. So this case has been going on for almost 5 years. It may be done, it may not be done, but just think about that for an ADA website litigation case. Now, the lower court held that Winn-Dixie's website did not comply with and violated the ADA. It was not accessible to Mr. Gill, and it presented a barrier to Mr. Gill's use, if you will, of Winn-Dixie. And so Winn-Dixie appealed that to the 11th Circuit, and the court just came out with an opinion less than 2 months, a little over a month ago, on it. And the court, it really is a key opinion, certainly for cases in its jurisdiction. First, it ruled that websites themselves are not public accommodations. So if you don't have a brick and mortar facility, business, warehouse, distribution center open to the public, your website in and of itself is not a public accommodation. Now, of course, Winn-Dixie did have numerous brick and mortar stores, and Gill would visit them. And the court drilled down into what Gill used the website for and what the website allowed. And what it held, and which was key to its holding, was the website could be used by Gill and others to refill prescriptions that were at Winn-Dixie's pharmacy, but he would still have to go into the physical store to pick up those prescriptions. They wouldn't be delivered or mailed or whatever to him. Second, he could use the website to utilize manufacturers' coupons to add to his Winn-Dixie card to get the effect of the coupons and the discounts on the food and merchandise he would buy at a Winn-Dixie store. But he would still have to actually go into the store to, in essence, quote unquote, redeem those points or those coupons. So what the court said is, well, the website's very limited. Even though you can do these things on the website, and Gill could not do them. So what Gill was saying is, look, I can't do them. So if I need a prescription refill, I have to go into the store. I have to go to the pharmacy counter. I have to maybe have someone help me, and I have to at least speak what it is, and then I have to wait for it, et cetera, et cetera. If your website operated, I wouldn't have to do that. They'd just be ready for me to pick up. Same with the coupons and the points. I'd already accumulate them. I wouldn't have to have someone look at the brochures or the pamphlets and cut out the coupons. The court recognized that, but said, Winn-Dixie's not selling anything. It's not a point of sale website. You can't order your groceries for delivery or for pickup on the Winn-Dixie website. You can't get your prescriptions delivered from the Winn-Dixie website. Anything you do on the website, you would have to come into the store to effectuate. And that being the case, even though that is an extra effort or is going to involve something that what other people might not have to do, it was not a barrier to your access to those services that Winn-Dixie's products and services that Winn-Dixie was offering. And so the court ruled and actually reversed the trial court and said, no, the website is one, not a public accommodation, two, does not violate, in conjunction with its brick and mortar stores, does not violate, and Winn-Dixie does not violate the ADA because of these claimed deficiencies in accessibility to the visually impaired of its website. And so the court reversed the lower court judgment and sent it back down. It's important to note this result is very dependent on the particular facts of the case, and this result can vary even in a case that's brought here in Florida or elsewhere in the 11th Circuit. In fact, the court, in its opinion, looked at two other cases. One was a case called Rendon, which involved the game show Who Wants to Be a Millionaire, which some of you may remember. It actually may be still on in different iterations. I remember it with Regis, but that's another story. And so to apply to be on the show, it was an automatic telephone application process using a touch-tone phone, and a disabled individual who had a disability of lack of hearing and also upper mobility issues said, I can't use this phone to apply to be a contestant on Who Wants to Be a Millionaire. And the very same court, this 11th Circuit, ruled in that case that that was a violation of the ADA. And what the court said in the Gill case is, well, that's a different situation, because that's the only way you as an applicant to get on to be a contestant on that show could utilize. There was no alternative. There wasn't a physical place you could go to or some other way you could apply to get on that show. And that's different from what we're looking at here with Winn-Dixie, because Winn-Dixie's not offering you something that you can only do on the website. Everything you could do on the website, you can do in the store, and it's not certainly offering any products for sale. The court also distinguished the Robles case, which was the Domino's Pizza case, which Dillon talked about. That's a Ninth Circuit case, because it said, and it was true, that in the Domino's case, you could order your pizzas online for either pickup or delivery. And the court said, well, that's a lot different, because you can't really order anything online at the Winn-Dixie. So that's a different situation. And clearly, if the court is faced with a website where you do order products and services online, I'm fairly confident the result would be a different result, even within the 11th Circuit. So yes, Gill is an important case. It certainly is important for those businesses that do not have a physical location, but it is limited otherwise to its particular facts and what the website actually allows and what usages can be made of the website. So with that, I'll turn it back over to Dillon to talk about, okay, what are we looking at in terms of standards?
Well, we're looking at the Wcag standards, and you may have heard me mention those when discussing the previous cases. The Wcag are the Web Content Accessibility Guidelines. In its current iteration, there's 2.0 and 2.1 standards. Now, as you may recall from the beginning of this presentation, we went through the different titles in which agencies enforce standards for Title I and Title II. And you may recall that Title III, there is no agency to enforce the standards, and instead the courts kind of go about deciding what standards to look at as far as the threshold for what constitutes compliance or non-conformance. It's important to note, though, that the Wcag standards, they're not made by a government agency or anything like that. Instead, they are promulgated by the World Wide Web Consortium, or the W3C, which is actually an international entity that broadly sets standards for the internet. So that's the realm that we're working in, are these standards that have been created not for the purpose of courts deciding compliance or not. However, some courts and some jurisdictions have looked at these standards in rendering their decisions. So what do these standards require? In broad terms, what's required on a website is that the content be perceivable, the links and your interactions with the website be operable. Generally, the website needs to be understandable. It needs to be robust in that any user can understand clearly what's on the web page, how to navigate the web page, and lastly, conformance with the standards set out by the Wcag. Now, just to go a little bit further with the Wcag standards, 2.0 is the current is a widely used recommendation by the W3C currently. And when 2.1 standards came in, they extended the 2.0 Wcag standards to more so maximize future applicability of accessibility efforts. In essence, they've kind of broadened the approach and have gone above and beyond with these new standards, almost in anticipation of the kind of shift towards e-commerce and online shopping and online business. So 2.1 has gone ahead and extended these standards to broaden them. The WCAG also has a certain criteria that they have, and this criteria is written in a way that it's testable. You know, these aren't subjective guidelines or subjective goals that the WCAG has promulgated or the WCAG has set out. They have to be testable statements, meaning that anybody who tries to use the website can have the access to the content and be able to use the website in its iteration and current design. So the website is tested, and the criteria set has to coincide with these testable statements. And the current guidelines in 2.1 standards have more so addressed accessibility to of web content across all devices. As many of you are aware, not everybody is always accessing a website on their home or personal computer anymore. Access on phones and tablets has become more commonplace most of the time for commerce and business, especially with the development and overreaching amount of applications that people can use. As most of you are can commonly see, you know, there's an application for everything now, regardless if it's banking, shopping, pretty much anything. So the 2.1 standards have definitely made an effort to address that the mobile websites that you come across on your tablets and phones also meet these standards. So now I'm going to kick it over to Keith to highlight some of the more important issues that most of you are probably concerned of, and that's the consequences of not complying with the ADA's website accessibility requirements.
Thank you, Dillon. And of course, the answer is comply. Don't be in a situation where you're not compliant. What does that mean if you're not compliant? We've spoken about injunctive relief, and that's the typical remedy, and that's a court basically ordering you as the business, and it may be as the business, as the manager, as the consultant, to comply with the ADA. And you may think, okay, that's okay, Judge. You know, we'll just say we'll take care of it, but you know, we'll line up some folks and handle it. Well, it's usually not that simple. As you saw in the Haynes v. Hooters case, the defendants Hooters said that exact same thing. In fact, they were in the process of remediating and said, Judge, we'll take care of it. And the lower court judge said, sounds good to me, and dismissed the case. And then the appellate court said, no, that's not good enough. So just for example, in the Gill v. Winn-Dixie case, the lower court judge said, you've got to redo your website, you've got to upgrade it, you've got to monitor it, you've got to do testing every 3 months, and all this has got to be subject to the plaintiff and with you know, an alley back to the court if you're not compliant. Winn-Dixie estimated its cost to do all that at about $250,000. So it can be a very large undertaking. Now, Winn-Dixie obviously is a larger established company, but the remediation is going to be in the thousands of dollars. There's no question about that, and probably for many in the five-figure thousands of dollars. And typically, it's not just one and done. There's going to be monitoring. There's going to be testing. There's going to be upgrades, maybe reports, investigations. Has to be, you know, the plaintiff, of course, is always going to be able to test it and check it, as will others. And of course, it's never good to not comply with an injunction, because that's a court order. And the typical consequence of that is you may be held in contempt of court, which is not a very good thing. And judges have a whole panoply of powers if you are found in contempt of court. So this is not to be taken lightly, clearly. Attorney's fees are typically awarded to plaintiffs. Now, going back to the earlier slide, if 97% plus are not in compliance, they're going to find something, and they're going to be awarded their attorney's fees. The longer the case goes, the higher those get. It's not unusual for them in a case like some of the ones Dillon was discussing, or Gill, they'll be in six figures. So not only are you paying your own attorney, you're paying the other side's attorney. You're also going to pay their costs, which are typically their expert witness fees, and there may be other costs as well. And then, as we mentioned, depending on the jurisdiction, you may also and venue, you may also be liable for damages. So it is not a very enticing landscape to want to go down. Next slide. So what do you do now? Okay, this is what you do now. Audit and remediate your website. Very, very important. Simply put, it is not simply done. It is very, very important, as the second bullet point mentions, that you have someone do that, a consultant, a business that does human testing and doesn't rely solely on automated tools. There is no silver bullet in terms of remediating websites. It is an involved process. You should not rely on overlays, widgets, simple JavaScript, other silver bullets. If any company tells you that, that is a big red flag. Dillon and I are certainly not going to recommend any entities or not recommend any entities, but tell you what you need to be asking them in terms of how they will do their testing, their auditing, and their proposed remediation. And if it sounds too good to be true or too cheap to be true, it most likely is. I will just give two instances. One, there is one entity that will remain nameless that is in this business that actually itself is now the subject of lawsuits in this regard. And there was another case, it wasn't one of the ones Dillon highlighted, but it was Andres Gomez versus General Nutrition Corporation. It was down in the Southern District of Florida, where the GNC's expert used automated tools and said, you know, website looks good to me. That's my opinion. And the court found, after listening to the plaintiff's expert and considering the evidence, said that's a no-go. Automated tools don't do it. You've missed 37% or more of the deficiencies in this website just using automated tools. Struck the expert's testimony. Basically means the defendant was without weapon in that fight, and of course naturally the plaintiff won. So you really have to be careful on who you're picking and to ask the right questions, find out how they conduct their auditing, their testing, their investigation, what their price is, et cetera, et cetera. There is a tax credit for small businesses. Most, if not all of you, would probably be in that category. It's up to $5,000 per year for website remediation. It covers businesses up to, I believe, $1 million in revenue and no more than 30 employees. So that's something you may want to look at or mention. Next slide. So what to do if and when sued? Obviously, it's an unpleasant situation. The first two, you want to do that in any lawsuit. That's certainly not limited to ADA website litigation. But I think it's especially true in these types of cases, particularly with respect to the jurisdiction and venue questions. That is, where the case is going to take place, because that's usually determined pretty early on in the case. You don't want to delay and lose an opportunity to object and say, no, judge, this case shouldn't be in California. It shouldn't be in Oregon. It should be in Florida, and here are the reasons why. Once again, as I mentioned, unlike Title I dealing with employment, there is no size floor in terms of employees. Small businesses sometimes are more likely targets than big operations for these types of suits. So you don't want to ignore it. And unfortunately, we have found out there are serial plaintiffs, if you will, that show up again and again and again, just as they did with the drive-by lawsuits. Typically, you don't get a warning, you don't get a demand letter, you get served with a suit. That's typically what happens. There is no requirement that they give you a warning that says, hey, your website's not compliant, fix it in 30 days, or we're going to sue. You just typically get served with the papers. And typically with these plaintiffs and their experts, they've already got their case packaged. They filmed the plaintiff utilizing the website. They filmed the deficiencies. They've got their expert consultant report that details all this. So they are really starting ahead of you. And so you really want to obtain counsel and respond very, very promptly. For that reason, and of course the other reason, the longer it goes on, the more the fees are going to mount and the costs are going to mount. You know, with every litigation, of course, there's you know, fighting versus settling, and you know, even though defendants fight this on occasion, and Winn-Dixie fought it certainly, and you could say Winn-Dixie ultimately prevailed after 5 years of litigation and probably a total of, you know, more than $200,000 in fees, and likely is going to remediate its website at some point. That's an expensive victory, quote unquote. Most defenses that you can think of have not really fared very well. Defenses of, well, you know, there's no standard because, you know, there's no DOJ standard like there is for physical locales. Courts have said, no, sorry, you know, we'll look to the WCAG standards. Well, you know, this plaintiff, he really is just one of these serial litigants that just is trying to test the website. You know, they don't really utilize the website that much. They're with an interest group or an advocacy group. Well, those defenses have pretty much been rejected. So that's not really going to go anywhere. You know, the mootness argument, well, you know, we're in a process of fixing it, or we think it's been fixed, or we've been sued before. Well, you know, that's all fine and good, but if they say it's still not compliant, then you still have a problem. So unfortunately, the landscape for available defenses other than the website complies, or depending on where you are, I don't have a brick and mortar location, it's just a website, or there's nothing that can be done on the website that can't be done at the brick and mortar, and the only things that can be done on the website have to be accomplished at the brick and mortar. There aren't a tremendous number of defenses, so in a way it is a plaintiff's very advantageous to a plaintiff, certainly if there are deficiencies in the website, which, as we've seen, is the case most in the great majority of the time. So with that, I see we have a few minutes left before noon. We'll open it up to any questions, Hiro, that you may have received.
Okay, great. Yeah, we have a few questions. Several two-parters. First question: do you have a disability? Do you have to have a disability to file a lawsuit? And where to get accessible features for the website to become in compliance?
Well, the answer to the first one is yes. You do have to have a disability to file the lawsuit. In the good old days, the disability had to match the issues you were complaining about. So if your disability was sight, if you were blind, you couldn't say, well, you know, your doorknobs at your location are round and they should be lever style. But if you were paraplegic, you could raise that, but you couldn't say, well, you don't have any Braille menus in your restaurant or audible, you know, features for that. But yes, you do have to have a disability. In terms of the items to you know, I'm not sure if it's physical items to get or website components. Once again, I'd ask Dillon to join in. Certainly advise going to a reputable and experienced consultant to ask about various web appurtenances that would be helpful in this regard. But overlays and those things, you know, if you're not remediating the underlying software, and just sticking something on the website's not necessarily going to help. Dillon, any thoughts on that latter one?
No, it really isn't a matter of, well, what can you add to a website to make it accessible? It's more of a holistic approach to the function and operation of the website. You know, sometimes it's for instance, if an individual is you know, limited or has sight impairment, the search boxes, drop down menus, you know, those have to be perceivable, they have to be understandable in the person's operation. So it's not necessarily always just a matter of adding something to a website. It really goes to the software under the website and the ability of the website to function with these e-readers and similar to that. So it's not a matter of just adding things to the website. It's really a whole view of the website and its function. And I mean, there's, even for people who, I'm sure many of you have come across a website you're trying to use and it just doesn't make sense regardless of any type of impairment or disability, where you can't find a certain item or it just doesn't flow properly. So imagine someone with a disability or more limitations. That's kind of what's in regards to what makes it accessible, not necessarily just adding an item to the website.
Great. I have another couple of questions. Can you recommend a good example of a website or a company that has those standards and follows guidelines and displays compliance to ADA for us to look at? And secondly, what is a good website company you recommend that we use?
Well, as I mentioned in my presentation, I am going to refrain because we don't want to give testimonials. That's not what this is all about. I think it's asking the right questions of the consultant or the company that you're dealing with, and once again, in terms of highlighting a website, there are certain, once again, that I'll have a big caveat. We don't want to say this one's good, this one's bad, but certain websites will have certifications that they are WCAG 2.0, 2.1 compliant, and presumably they have gone through the steps to make them compliant. So if I were looking for websites, I might be looking for those certifications on the websites and maybe look at those. Dillon, any thoughts?
No, that's where I was going to approach as well. There are certain websites that you can look as exemplars to see the various certifications and standards on the websites itself. As far as finding a source for guidance, there's multiple sources. If you search online, you can find certain companies or consultants. But in reality, I think it's key. Walking away from this presentation, it's key to just understand the right questions to ask when you're dealing with those individuals or companies to ensure that your website is in compliance. And again, it's not only a one-time compliance. Who you're working with to make sure that your website is accessible. It's an ongoing process, and who you work with has to be knowledgeable and perhaps have the foresight to see certain deficiencies that may develop down the road. So it's not just a one-stop shop, get it done. So it's got to be an ongoing conversation with an individual you feel comfortable with or a business you feel comfortable with and their consulting ability.
Cool. All right. And I think the last question so far. Today, the majority of companies are interacting with their clients or simply taking advantage of the e-commerce boom, particularly after the pandemic. However, there are companies that are using their websites for institutional information purposes only. The question is, do you know how many or the percentage of companies that are using the website for information only to get involved in lawsuits?
Okay.
Dillon, do you know of any?
I do. There is some case law that I've seen as far as a statistic, whether or not it's an e-commerce website where they're strictly selling or selling items, shipping items, versus whether or not it's just access to the website for informational purpose. As far as statistics on the percentage of what builds the case or what doesn't, I don't have that figure, but I can tell you there are a certain number of cases where where the focus is not on the business transaction or the consumer's transaction on the website. It's a matter of seeking information. So yes, right. even if the website doesn't provide any tools or efforts to conduct business with the company, if it's just a matter of fact finding about, for instance, a lot of cases with regards to hospitality, hotels, there's a litany of cases where, especially your mom and pop hotels, your bed and breakfasts, where an individual out of state wants to quote, get information about the accessibility of the facility. So they go to that website for information regarding the accessibility of the building. And there's been cases where the website is not up to snuff with regards to their ability to navigate the website to find the necessary information. And also, if a website doesn't have the information regarding accessibility, those two items have been a point of litigation. But going back to the initial question, I'm unaware of a specific statistic to show one versus the other. But even if your website is only providing information, it still needs to be in compliance and accessible to those with possible disabilities.
Yeah, I'd only add in the Title II area, certainly with governmental entities, that typically is information is typically provided, although you can certainly do things, pay fines and do, pay bills and whatever. But I give the example of, well, the televised county commission meeting, or, you can view it on your laptop, certain governmental proceedings. That's purely informational. And there have been cases certainly brought by the hearing impaired that says, well, your closed captioning's not working. I can't follow. I can't, et cetera, et cetera. And there have been lawsuits, and those are certainly situations where that's purely informational, right? You're not buying anything. You're not getting a service. You're just accessing the website, and it is inaccessible to you for one reason or another. So certainly from a theoretical standpoint, in those instances, there's nothing. Although in terms of, well, we're non-governmental entity, we're not Title II, it's just the website, it's not a public accommodation. I've not really seen many cases in that area.
Okay, I believe those are all the questions we have so far, unless anybody wants to add another one. Okay, nope. All right, cool. So we'll just go ahead and close this webinar out. Dillon and Keith, thank you so much for your presentation today. It was very educational. There's a lot of great information shared. We appreciate. I'm pretty sure all the attendees feel the same way. Thank you so much.
You're welcome.
If you have any to our attendees, if you have any questions, please feel free to contact Keith and Dillon directly. You see their email addresses and the contact information here on the slide here. For any information regarding ADA compliance or any other business law matters. Like I said earlier, please be on the lookout for a webinar evaluation survey. Let us know how we did today and what the programs we can provide in the future. So with that said, I'll wrap it up. Thank you so much.